Now at 5, as we reported at the top of the newscast, 1 hour after a Florida judge signed a temporary block to the 15-week abortion ban, the state appealed and the block was nullified.
And for a better understanding of what this means, we're joined right now by Nova Southeastern University law professor Robert Jarvis. And Professor, first of all, thank you for joining us. What is next for these health providers who are trying to expand abortion access?
Yeah, that's an interesting question. Right now, they have to do nothing. They have to stand down because the new law is back in effect, and they'll have to wait to see what the First District Court of Appeal in Tallahassee decides to do.
This seems like it could all potentially become a big back and forth between the judge and the legal system and the governor and the rest of his administration, going back and forth with appeals and then blocking and then nullifying the blocks. How long can we potentially be seeing them deal with this in the courts?
Yeah, I mean, it's hard to say. I think it will move very quickly. I think that the First District Court of Appeal in Tallahassee will either very quickly decide that Judge Cooper was wrong, or alternatively, they could try to send the case to the Florida Supreme Court. And I suspect that if they do that, the Florida Supreme Court will accept the case. But I think probably the next year or so, we could see a back and forth. It just depends on what the judges decide to do.
One more question. When this ruling first came down, we heard, and we had heard before from legal scholars, that Florida's Constitution has a protection of privacy, right, which was the basis of Roe v. Wade. Will that be the argument that the attorneys who want to overturn this law will make in court?
Well, actually, our constitutional provision, which we put into our Constitution in 1980, is separate and apart from Roe v. Wade. So we're really past the point now of thinking about Roe v. Wade. The real question is now, what about a case called In Re TW? That's a 1989 Florida Supreme Court decision that said no matter whatever happens to Roe v. Wade, it doesn't have any impact here in Florida because we have this special separate privacy provision in our Constitution. So that's really where our focus is now. In Re TW, it's no longer about Roe or Dobbs, the case that the U.S. Supreme Court just used to overrule Roe.
But if it ends up in the U.S. Supreme Court, we know what's going to happen given the makeup of the court, no?
This won't go to the U.S. Supreme Court. This is now purely a state law issue. That's what the U.S. Supreme Court did in Dobbs. It said we no longer want to handle, we no longer want to hear abortion cases. So this is now firmly a Florida Supreme Court issue.
And as the Supreme Court seems like it wanted all along to have this be a matter handled by each of the states individually. Robert Jarvis with Nova Southeastern University, thanks so much for being with us tonight.
Thank you.